Florida mom is banned from being around her own son after she allegedly left him by himself at just 5 years old.
Who else is in the house with you?
No.
Nobody's home.
Mama left you home alone?
And what they discovered inside the North Miami Beach home caused officers' concerns to skyrocket. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. All right, before we go any further, I just want to tell you real quick about the sponsor that we have, this app. It's called Upside. This is a game changer. Why do I say that? Because Upside gets you cash back, extra cash back on everyday purchases like gas, groceries, takeout. So here's what you do. You download Upside for free, you claim an offer at one of their 100,000 plus locations, and you pay like normal with your card, and then you verify the purchase, and just like that, money back. So say I need to get gas or I want takeout one night, I'll search for Upside offers first, and after I spend, money's going to appear in my app that I can then transfer straight to my bank account. And Upside's frequent users, they earn an average of $254 back a year. So to start getting your cash back, click the link in the description or scan the QR code and use promo code SIDEBAR to get an extra 25 cents bonus on every gallon on your first tank of gas. Back on March 7th of this year, police officers made a shocking discovery on a street corner right around the time that it started to get dark. A little boy standing by himself, seemingly looking for help. North Miami Beach police officers' body cameras were rolling as they tried to figure out what exactly was going on from a timid and terrified child.
You live in there, right?
By myself.
You live in there by yourself?
Because my mom left me.
Because your mom left you.
What happened?
You say your mom left to Walmart, left them home.
Walmart is northeast.
Is there anybody that lives with you? No? Just you and mom? Yeah? And mommy went to Walmart? Did she tell you how long she's going to be?
And a 36 from 2020.
No?
She didn't tell me what time she would come.
She didn't tell you what time she's going to come back? Aw. But we'll find mommy, okay?
19th of May.
We'll find mommy. Alright. I'm glad you're okay. I'm glad you're okay. And you live in the back? Yeah. Okay, we'll find mommy, all right? You have any brothers or sisters? Just you? And you're, how old are you, 5? Man, you're big and strong, man. You're big and strong. Okay.
What's up, buddy? Hello, young man. How you doing?
So his mom went to Walmart. Mama went to Walmart.
So what, you just found him here?
Just, yeah, we're standing over there.
In the corner?
Yeah, the boy tells police he's 5 years old, that his mom had gone to Walmart, but that she hadn't come home yet. Now, his identity is blurred out in the video clips that were released by police, but he appears to be wearing a long-sleeve shirt, no pants, no shoes. His mom, later identified as 23-year-old Britley Louis, is nowhere to be found, and an officer does his best to keep the boy calm as you have other investigators try to get to the bottom of what's going on here, even singing the ABCs and the Itsy Bitsy Spider.
Like police car? Come here. Come sit in my car while we wait for your mom, okay? Huh? Have you been inside a police car before? See, look, it's clean, nice. All right, just have a seat, okay? I'm gonna leave the door open. I'm gonna stay with you the whole time, okay? See, I have the lights, I have everything. You like cars? What's your favorite cars?
Police.
Huh? Police cars? You go to school?
Not yet.
What school do you go to? You know the name of your school?
Not yet. I'm not going to school yet.
You're not going to school yet? Okay. So you don't know your ABCs. You don't know your ABCs, right? You want to sing it with me? A, B, C, D, E, F, G. I know you know it. H, I, J, K, L, M, N, O, P. What's next? Come on, what's next? Q, R, X, U, W, Y, and Z. Now I know my ABC. Next time, won't you sing with me? See, you know it. Why you pretend you don't know it? What else do you know? What's your favorite song? You don't remember? You know Hipsy Pitsy Spider. You know the Hipsy Pitsy Spider. You know? You know that song too? Yeah, you do. You laughing because I start singing it because I see you laughing. It's okay. Give me 5.
And while this 5-year-old boy just waited in the car, according to an affidavit that we reviewed, officers found the open door that the boy had used to leave the home, but no one was inside. But when you look at the conditions, according to police, that may change everything because those conditions were reportedly appalling. According to arrest paperwork, there were stacks of boxes 3 to 4 feet tall, as tall or even taller than the boy himself. The officers described the home as showing signs of hoarding with dirt and spider webs everywhere, food rotting all over the place. And apparently, when they opened the refrigerator, the smell was, quote, extremely unbearable. Now, authorities tried reaching Louis, but they actually weren't able to until she reached out to police several hours later. This is according to the affidavit. And she claimed, and she apparently said, that a friend would be coming by to pick up her son. But that friend apparently never showed up. But police ended up contacting her too, and she said she wasn't comfortable taking the boy. She also said she didn't know where Louis was. Now, this 5-year-old was eventually turned over to the Florida Department of Children and Families. The officers, they went back to the house the following day, March 8th, and they finally found Louis, arresting her for 1 count of child neglect without great bodily harm and unlawful desertion of a child, both felonies. And at her first appearance, a judge granted her a $5,000 bond, which she apparently posted according to the court docket, but she's forbidden to have any contact with her son. Now, this bond modification paperwork that was filed with the court reveals a bit more about Louis. According to her public defender, she had lived in the Miami area for the past 10 years, had worked for Delta Airlines for 4, so you're talking about a steady job. The boy's father passed away 3 years ago, so Louis was a single mother. And her defense also said she had no criminal record. And this is all important, and we'll talk about what it could mean for her case moving forward. So let's get into this. Okay, I want to discuss this a little bit more. I want to break down the law on this. So joining me once again, I haven't seen her in quite some time, practice professor of law, former child abuse prosecutor, Marian Braccia. Thank you so much for taking the time. Always good to see you. It was funny, before you and I got on, you said, I want to pull up the statutes on this. I was like, I already have them. You said it. Great minds think alike. Okay, so I wanted to ask you, I'm going to read you the statutes. I'm going to read you the definitions. You tell me, based on what we're seeing the reporting, based upon the fact pattern put forward by authorities, if it matches. So if we're talking about child neglect, the Florida statute defines neglect of a child as a caregiver's willful failure or omission to provide a child with the care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to food, nutrition, clothing, shelter, supervision, medicine, and medical services that a prudent person would consider essential for the well-being of the child. The term does not include a caregiver allowing a child to engage in independent and unsupervised activities unless allowing such activities constitute willful and wanton conduct that endangers the health or safety of the child. Such independent and unsupervised activities include, but are not limited to, traveling to or from school or nearby locations by bicycle or foot. I don't think that one really applies. Does a caregiver's failure to make a reasonable effort to protect a child from abuse, neglect, or exploitation by another person. Yeah, that one doesn't apply. So it's really that. Let's start with that charge, and then we'll move on to the other one. You tell me, is this child neglect?
So first of all, it's nice to see you as well. Thank you for having me back. I think that if this were an isolated incident, I think that if the only evidence that the prosecution had was the fact that the child flagged down police officers and reported that he'd been left home alone, that might be considered an isolated incident and something that's perhaps worthy of social service intervention or worthy of some kind of supervision or family oversight. Not sure if a one-time incident where the child saying, my mommy went to Walmart and I don't know when she's going to be back, I don't know that would rise to the level of the standard of neglect that the statute imagines. However, what we have in this case is evidence of the child's living conditions that I think carry the day in a much more stringent way than the reporting on this, what some might consider an isolated incident, right? So you'll have the responding officers who are available ostensibly to come in and testify to the conditions of the home, the availability of food, the cleanliness of the home, the basic hygienic or unhygienic conditions that the child was living in. And I think all of those details will go to what some courts call a course of conduct, which would deprive the child of the healthy living conditions that the child has a right to that would ensure the child's physical and certainly mental health.
I think you articulated it perfectly. It's not just one isolated example, right? It's a totality of factors, of alleged factors here. And when the statute says a person who willfully or by culpable negligence neglects a child, feel free to talk about what that means and why that's important. But you're right, it's not just the living conditions. So somebody might be saying, well, what does that mean? I have to keep my house in tidy order, otherwise I'm going to be charged with child neglect? Not necessarily, right? I think it's where the child was found, what the child said, the conditions of the house, also the allegation that she never picked the child up, right? The idea, I'm going to send a friend to pick the child up, didn't. So talk to me about a little bit more about this. If we're talking about, was it willful or by culpable negligence that she neglected the child or allegedly neglected the child?
Yeah, and I think based on what you described, I think the prosecution would have an argument under both standards in terms of the willfulness and culpable negligence. As you know, and I'm sure as many of your viewers know, most of the laws in our American system are based on what we call the reasonable person standard. So we have to consider what our reasonable average person walking down the street, person in this parent's position would have done. So we'd be asking essentially a jury of this eventual defendant's peers, was it reasonable for her over however much time to have exposed the child to these living conditions? Is that someone who was disregarding the standard that we have set as a society for what we think is acceptable and reasonable, essentially the minimum required to be deemed a caregiver? And so I think the prosecution would be asking a fact finder, either a judge or a jury, to take a look at this totality of circumstances, the conditions of, of the home, the length of time that the child was left unsupervised, the availability or unavailability of the mother to respond to police outreach, to then show up when she said she was going to and pick up the child. All of that goes to, one of our favorite phrases in the law, totality of circumstances, to show that not only was this willful, not only was there a knowing disregard for the well-being, the safety, the care of the child, but then at the same time, we're saying, even if you are not a great homemaker, even if you do maintain a messy house, I will plead guilty to that right now, that is the reality of your situation as a parent. This falls well below the standards that we as a community and as a society have set for what we expect caregivers to do for their children or those in their care.
Let's go to the desertion charge. I looked this up too. They say desertion or deserts means to leave a child in a place or with a person other than a relative with the intent not to return to the child and with the intent not to provide for the care of the child. So back to you. Can a defense be, hey, my son was mistaken. I was coming to pick him up.
Yeah, I think that's a touchy area in the language of this statute, right? Because the prosecution would have to show an intent to permanently desert, right? To say, I'm leaving and I'm never coming back. We, again, as a society, might not approve of or appreciate a parent leaving, especially a child this young, for a certain amount of time, for an extended period of hours, even I think for a weekend, as the child had initially reported. So we can all, ordinarily we would say, again, as a society, that is just not reasonably prudent care that one would show to their child or someone in their care. But at the same time, the defense is going to say, what is your proof that this parent intended to permanently desert, that this woman was never going to come back? Was she packed? Did she take her belongings with her? Did she leave anything behind in the apartment? Her her home, her passport, her ID, her vital records, her birth certificate or social security card? Where is your proof that she was leaving town and never coming back? If there is that a requirement in the statute for proof of an intent to permanently desert. So I think that might be an argument that the defense makes. And, again, it's one that the prosecution would have to go back to the circumstances under which they encountered the child and how long the child had been left unsupervised, and frankly, whether or not this had happened before. And I know that we've talked a lot about that in the past, about other acts and how they can inform the intent or the finding of intent in a particular instance. But that might be something worth investigating for both the police and the prosecutors.
Let me ask you this. If this were to go to trial and she was convicted, and I understand these to be third-degree felonies with potential punishment of up to 5 years in prison on each charge, I mean, correct me if I'm wrong, that's the way that I saw it. Would that be stacked? Would it be 5 years in total? Would it even be 5 years? Could it be stacked on top 10 years? What do you expect for something like that?
Well, I think a lot goes into a sentencing decision. As you know, we don't know, or at least I don't know, her any potential prior criminal exposure that she may have.
I think she has, according to her attorney, she doesn't have a criminal history.
So a prior record score would certainly be factored into the sentencing decision. If she has no prior contacts, if there's been no prior reports to the Department of Child and Youth Services, that would certainly impact the sentence. Now, of course, that 5-year max is the statutory availability that a sentencing judge would have. Could a judge sentence up to 5 years on each charge if she were convicted on each charge? The answer is yes. Would they? I think it would depend on the judge. In my experience, likely not, because of the 0 prior record score, and because I think ordinarily there is an interest, especially when we're dealing with cross courts like family courts and criminal courts, there is an interest in keeping parents with their children, keeping children with their parents, and trying to improve the social and the home situation. But to answer your question, could these 5-year sentences be stacked? They could, because they're not. They are separate statutes. They don't merge, if you will, and one isn't a lesser included of the other. So they could run consecutively for a period of up to 10 years. Would they? Likely not. But again, that would be within the discretion of the sentencing judge.
If this went to trial, would her son have to testify against her, or you say, we don't need to do that? We have the body cam. We'll use that. Or do you need him to testify?
Well, remember, if they play the body cam video in court, anything that the child is heard saying on the body cam is technically considered hearsay, right? Because we've talked about the definition of hearsay before. It's anything that's said outside of court that we want the fact finder to accept as true, to accept as a fact that's been proven or presented in the case. So technically, whatever the child would have been heard, would have been recorded saying to the responding officers would be considered hearsay. A prosecutor who knows their evidence law would go through the available exceptions in the evidence code and find whether or not there is an exception to hearsay that would admit those statements in terms of perhaps the child's present condition, like a present sense impression, or the child's then existing emotional state, saying I'm scared or I'm lonely or I'm hungry. That would be something that would
Can
be
I just jump in
accepted.
real quick? So you're saying there's a possibility if that was played and the child says on camera, my mom left me, she told me she was going to Walmart, the judge would have to instruct the jury, you can't use that to say that's evidence clear as day of desertion or child neglect. It can be used for another purpose, it can provide context, but you're saying that's something we should be considering?
That is definitely something that you should be considering. But again, the prosecutors are going to consider whether there is what I'll call a creative outlet, an ethical creative outlet that they can use within the rules of evidence and within the strictures of the rules of evidence to find an exception to admit those statements from the child, even for their truth, meaning as a fact that they are asking the judge or the jury to accept as true. So this is all kind of part of the pretrial strategy that the prosecutors would go through. Would the child have to testify? In all likelihood, I would, if I were handling this case, I would likely rest on the observations of the responding officers in terms of the condition of the child, the demeanor of the child, how they were presenting, if they were shaking, if they were scared, if they were shivering, if they were cold, anything like that. And then certainly my on-scene personal observations of the home and the living conditions of the child. And I think evidence like that, especially if it was documented in terms of if the officers were still reporting on their body cams or if photos were taken of the scene, I think that visual evidence would be very powerful to prove the substandard living conditions of the child.
And if they can testify that she never picked him up, right? That as well. Let me ask you this. Do you think this is going to go to trial, a case like this, or do you think that there could be some sort of negotiated plea?
Well, I think that obviously a trial is an absolute right for any defendant who's charged with a crime. So if this defendant wanted to hold the government to its burden and say you have to prove every element of every crime charged against me beyond a reasonable doubt, that is the government's burden every day of the week. And so that would be perfectly within her absolute right to demand that proof. I could also envision a world where, again, if there is a cross collaboration or cooperation between courts like family courts and the criminal courts to arrange some kind of either negotiated plea or some kind of suspended sentence to get her, again, the social services that she needs, the social supports, maybe even the parenting classes, if there's anything else going on, that a pre-sentence investigation would reveal anything in the way of mental health treatment that's necessary or even substance abuse treatment that's necessary. I would envision a court being forward-looking and wanting to prevent further harm to the child and certainly to this parent as well. So I could see a creative sentence being negotiated to make sure that this family gets the services they need.
One of the things that I find interesting is the bond modification paperwork in this case, because sometimes bond modification, it's a different standard for, obviously you're asking a judge to reduce or modify bond. It's a different standard than if you're talking about the evidence used to show someone's not guilty of a crime. But I do think it sometimes can give you a preview of where the defense may go, maybe even give you a preview of some of the mitigating factors they may argue at sentencing. So one of the things they basically say about the $5,000 bond is she doesn't really have an ability to pay any amount of bond. They say basically holding her is tantamount with no bond. They say she's not a danger to the community. She has absolutely no criminal history in Miami-Dade County. She's not a flight risk. She has lived in Miami for the past 10 years. She has extensive ties to the community. She has family here, including her son, sister-in-law, mother-in-law, and that her partner, so the boy's father, passed away 3 years ago, and so she is a single mother. Any of that, and I haven't seen the latest regarding the bond paperwork, bond status. I don't know if it's changed. I don't believe it has. Anything, those factors we should think about in terms of bond, but more importantly, as this case potentially progresses, in terms of sentencing or arguments at trial?
Well, all of those statements are judicial admissions, and they are available to the prosecution to use against the defendant. And so when I hear those arguments for amending the bond condition, a few things come to mind. First of all, the argument that she's not a flight risk. Well, she is, or at least an argument can be made that she is, because she didn't show up when she said she was going to show up, and she left her child for however long that she left her child, allegedly, of course, because it has to be proven in court. So that would be the argument I'd make against the flight risk, or the lack of flight risk argument. And further, when the defense states that she has significant family support, they're also including the 5-year-old that she, again, allegedly deserted, but they mention a mother-in-law and a sister-in-law who were not notified and who were not called to come to the scene to help care for this child or come pick up this child. She called a friend who also didn't feel comfortable coming to pick up the child. So I think there are arguments cutting against what the defense represented in terms of her community support and her intention to remain present and fully participate in the defense of her own case.
Professor Marian Braccia, always great to have you. Thank you so much for breaking it down and in a way that we can all understand. Thank you. Appreciate it.
Thanks, Jesse. Have a great weekend.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can also check us out on NBC's Peacock as well. We have Sidebar episodes up there as well. If you want to follow me, X, Instagram, my News Nation show, Jesse Weber Live, Monday through Friday, 11 p.m. Eastern. I'll see you next time, everybody.